Getting an uncontested divorce or a simple divorce is thought by many to be a straightforward process. As a result, many people who try to do their divorce on their own are surprised when a judge refuses to grant the divorce. There is no absolute right to a divorce. In this episode of the Ontario Family Law Podcast, I will go over the reasons that a judge can refuse a divorce to help separated couples succeed in becoming divorced. I'm John Schumann, a certified specialist in family law in Ontario. I'm also a mediator, arbitrator, and collaborative lawyer. This podcast is a companion to my book, Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and in fine bookstores. Divorce legally ends a marriage in Ontario and Canada. The divorce order itself does only that and allows the spouses to get remarried again. So people usually get a divorce when they want to remarry or have the option of getting remarried, or because they want to formally put an end to their marriage. Since common law couples were never married, they do not have a marriage to end, either to marry someone else or otherwise, and so common law couples cannot get a divorce. That does not mean they cannot ask for parenting or support in court. They can still do that and seek the relief available for common law couples, which does differ from what married couples can ask for. I have covered that in previous episodes and in more detail in my book. To get divorced, a married couple must have not been living together as husband and wife for at least 1 year prior to divorce. That does not necessarily mean that they must have lived in separate residences, but it does mean that it would be apparent to anyone who knew them that the marriage was over and they must not have been doing things in their lives the way that a married couple would. The date that it was clear that the couple had stopped acting like a married couple and there was no reasonable prospect they would resume their marriage is the date of separation. To get a divorce, the date of separation must be at least 1 year before the date the judge grants the divorce, and this is one of the things that judges look for. I have a whole other episode that covers whether spouses can be divorced in Canada, particularly where they came from other countries. A judge will refuse to grant a divorce in Canada if at least one spouse has not made Canada his or her home for at least 1 year. The judge will also refuse to grant a divorce if there is a spouse outside Canada who was not served properly in accordance with the treaties with respect to service of court documents. For more about those rules, check out episode 55, Can You Get Divorced in Canada? Also, for uncontested divorces, the spouse asking for the divorce must have properly served the other spouse and waited 30 days to see if that other spouse objects to the divorce. Services of divorce papers in Canada must be completed by special service. There are 4 ways to do that, but it is necessary to strictly follow the rules for service set out in Rule 6 sub 3 of the Family Law Rules. Otherwise, the court office should not even accept the divorce documents. Also note that Rule 6 Sub 4.1 says that one spouse cannot serve a divorce application on the other spouse. It must be served by someone else, either a process server or someone else who knows how to follow the rules for special service. In addition, the person who serves the divorce documents must swear an affidavit of service that is in Form 6A to prove that the other spouse was properly served. Without that affidavit of service, the court staff will not allow a spouse to proceed with a divorce. There are some things the court will do if the other spouse cannot be located or otherwise is avoiding service, but doing those things requires a motion before the court, and that likely means getting the help of a family law lawyer. Another hurdle can be that the court staff may refuse to accept divorce documents if they are not completed properly. Some people find court documents difficult to understand, and the court rules difficult to follow. If that is you, then it's best to get advice from a lawyer. Many family law lawyers will give help on limited scope retainers, which means you can hire them just to help with the court documents or other individual steps in the process to get a divorce. It is true that it is theoretically possible to get a divorce in less than a year on the grounds of adultery or cruelty. However, there can be legal consequences for admitting to cruelty, and both parties to the adultery must admit to it. If the necessary admissions are not forthcoming, and for various other legal reasons, they very rarely are, the cruelty or adultery must be proven in court and at trial. In addition, if at trial or before the spouse that committed adultery can prove that the other spouse condoned the adultery or participated in it, then the court cannot grant the divorce on the grounds of adultery. Technically, this is true with regard to cruelty as well, although there are some other legal considerations regarding whether someone can agree to being treated cruelly. Regardless of all these legal technicalities, going through all the court steps to get to a trial, which I explained in previous episodes and in my book, takes more than a year. So it is quicker, easier, and less expensive to just wait for that year. Another reason that a judge can refuse to grant a divorce is if there are children of the marriage and appropriate child support is not being paid. Where there are children of the marriage, the spouse requesting the divorce must include in the affidavit for divorce the incomes of the parents, the arrangements that the parents have made for child support, and confirmation that the child support is being paid in accordance with those provisions. Judges are required to refuse a divorce if child support is not in place and if the child support does not benefit the child as much as an application of the child support guidelines. If the judge can see from the party's income that the child support is being paid exactly as required by the child support guidelines tables, then child support will not be a problem in getting a divorce. If you need to make sure that the child support is as required by the child support guidelines, that is covered in greater detail in my book and in several episodes of this podcast that will be linked in the description. If the parents want to make arrangements for child support that benefit the child as much or more than the child support guidelines, but those arrangements are not exactly as set out in the child support guidelines, then the parent asking for the divorce will have to explain why the arrangements benefit the child more than just using the child support guidelines. A judge can also refuse to grant a divorce if the judge believes there has been collusion between the spouses. That means that the spouses are not asking for the divorce because they want to end their marriage, but because they are trying to get the divorce for some other improper purpose. And so they are fabricating evidence about the breakdown of the marriage. There may be financial incentives for two people to be divorced, and so the spouses are essentially committing fraud to benefit illegally. If a judge believes that, then the judge will deny the divorce. Finally, a judge can refuse to divorce spouses if the spouse requesting the divorce has not cooperated with getting a religious divorce for the other spouse. Section 2 of the Family Law Act permits the court to dismiss the spouse's claim for divorce if that party refuses to confirm to the court that he or she has removed all the barriers that are within his or her control that would prevent the other spouse from remarrying within that other spouse's faith. The court will only ask for this confirmation if a spouse raises that issue, which the spouse is only likely to do if the other spouse is blocking a religious divorce or annulment. Still, a spouse is only required to do what he or she can in their religion. Where a religion does not permit divorce or remarriage, a spouse can't do anything about that, and so that is not a bar to a civil divorce. Many separated spouses are disappointed when a judge refuses to grant their divorce. Sometimes that is just because the forms are completed improperly. Other times it is because there is a legal issue that prevents the spouses from qualifying for divorce. Getting divorced is not a right. The spouses have to meet the criteria for getting divorced. Usually the problem is related to child support or an issue related to whether the court documents were properly served. But there are other problems that can arise. To avoid them, it is often best to get the help of a family law lawyer who can help get the divorce as quickly as possible and without problems. That is especially important where one of the spouses is getting remarried. It is a real pain to have to reschedule a wedding because the divorce didn't go through. With what a wedding costs, it is worth paying a lawyer a little to make sure that divorce does not cause a problem for the new wedding. If you need more general family law advice or children's law guidance, or you need to understand Ontario family law better so you can make better decisions, if you need to know the best parenting options after separation, or if you need help with a child protection issue, or you need to understand how finances work after separation or divorce, get a copy of my book, Guide to the Basics of Ontario Family Law. You can access it immediately on the iBookstore on Amazon for the Kindle version, or you can download it for Kobo. Amazon can deliver the paperback version directly to your doorstep. You can also get a lot more Ontario family law information on www.humanlaw.ca. Not only are there hundreds of pages of family law information and links, but there are links to get my book and links to reach my office to meet with either me or one of my colleagues. You can also set up an appointment to speak with us by calling 416-446-5847. It is always best to get a lawyer who can give you expert advice that is specific to your situation. In addition to my website, keep up to date on family and children's law issues by liking my Facebook page, following me on Twitter at @HumanFamLaw, and finding me on LinkedIn. Of course, please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast in all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, Amazon Music, and many more. Or you can get the episodes at www.humanlaw.ca. Just look for podcast in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.